These are the
You did.
papers.
It's pretty.
This was done by the military, given to me. I think we can probably, right?
I don't know. We'll have to see. Yeah, we'll have to try to
Declassify.
figure out yeah.
See, as president, I could have declassified it.
Yeah.
Now I can't, but this is classified.
Now we have a problem.
Special Counsel Jack Smith's indictment of Donald Trump details two specific instances where the former president allegedly showed classified material to people who didn't have the proper security clearances. You just heard an audio recording from the first instance, which took place during a July 2021 meeting at his Bedminster, New Jersey golf club with two of his employees and a writer working on a book about Mark Meadows. Here's what the indictment says about the second time it happened. Quote, in August or September 2021, when he was no longer president, Trump met in his office at the Bedminster Club with a representative of his political action committee. During the meeting, Trump commented that an ongoing military operation in Country B was not going well. Trump showed the PAC representative a classified map of Country B and told the PAC representative that he should not be showing the map to the PAC representative and to not get too close. The PAC representative did not have a security clearance or any need to know classified information about the military operation. Thanks to new reporting from the New York Times and other outlets, we now know that, quote, the representative of the PAC was Susie Wiles, one of the top advisors for Mr. Trump's presidential campaign, according to two people briefed on the matter. The fact that Ms. Wiles could become a prosecution witness should Mr. Trump's case go to trial, even as she is helping run his third bid for office, underscores the complexities that the former president now faces as he deals with both a presidential campaign and a criminal defense with an overlapping cast of characters. The Times also reports that the Miami grand jury is still actively hearing evidence and testimony as part of the case. Quote, 3 weeks after former President Donald J. Trump was indicted on charges of illegally retaining national security records and obstructing the government's efforts to reclaim them, a federal grand jury in Miami is still investigating aspects of the case, according to people familiar with the matter. In recent days, the grand jury has issued subpoenas to a handful of people who are connected to the inquiry, those familiar with it said. Joining us now, Barbara McQuade, former U.S. attorney and a law professor at the University of Michigan Law School. She's also an MSNBC legal analyst. Barb, what do you make of this second event at Bedminster with the Trump advisor, Susie Wiles? Could this potentially lead to separate charges being filed in New Jersey?
It could. It may be the kind of case, Jonathan, where they would want additional evidence, maybe the document itself. My guess is the way they know about that is from Susie Wiles herself, that a witness told them. They don't know the precise date. They know it happened in either August or September. That sounds like someone's memory trying to reconstruct when something happened. Maybe there is someone else present in the room, but there are real witnesses who can testify to that. Ordinarily, I think prosecutors want to have more evidence than one word against another. But if you couple that with the other episode that occurred in July, where we heard that audio recording, you start having some pieces of a case there to put together. And again, in that July episode where there is the recording, it won't be just the recording, but the people who were present to hear that conversation. So I think prosecutors probably could file charges there. Strategically, they may prefer to be focusing on Miami, where they have more incidents, more evidence. And it could be that Bedminster, a separate indictment, would be a distraction from that case. But or sometimes you wait and see how things go in Florida, and you keep that in your back pocket in case you need to play it.
Okay, you invoked the city, Miami. What about the ongoing grand jury activity in Miami? What more would they be investigating at this point?
Yeah, I think this is really interesting news. Ordinarily, once a case is indicted, prosecutors are not permitted to use the grand jury just to bolster the evidence in that case. They can't bring in more witnesses just to prove what's already been charged. They must be investigating new crimes or new defendants to add to this case. So that's a really interesting question. It may be they've learned additional things. It may be that they wanted to put a marker down, file the charges, and continue to investigate other aspects. But I'll tell you, one kind of factor that causes this sort of ongoing investigation is after charges get filed, sometimes you learn that a defendant is tampering with witnesses or doing something to destroy evidence. And that can be the kind of thing that you investigate even after an indictment is filed. So we don't know what it is, but it's really interesting that they're investigating perhaps additional crimes here.
Let me get you on one more thing, Barb. CNN is reporting that Michael Roman, who served as the Trump campaign's director of Election Day operations in 2020, is cooperating with Jack Smith's January 6th investigation. Can you explain briefly what the mechanics of that proffer deal might look like and how investigators would be able to use any information they get from him?
Yeah, so a proffer is sort of a first step toward cooperation. It's kind of a test drive for prosecutors. Sometimes a lawyer will say, my client wants to cooperate with you in exchange for leniency in a plea deal. And prosecutors might say, well, let's take it one step at a time. Let's bring him in and hear what he has to say. They'll sign a proffer agreement that says anything the client says in this session will not be used against him as long as he doesn't lie. And so that seems to be the step, but that often leads to a cooperation deal and a person agreeing to testify against the defendant.